Hi, and welcome to What's the Tea in L&E. I'm Leah.
I'm Emily.
And we are management side employment attorneys with Woods Rogers. And today we are talking about policies that companies should put in place for independent contractors and temp workers that they either have on site or that are either working with their employees.
Okay, but Leah, why would I need policies for temp workers or contractors? I mean, isn't that the whole point? They're not employees?
That's a great question. Well, a few years ago, I had an EEOC charge for a client. This was a healthcare institution, and they hired a traveling nurse company because they were a little short-staffed.
Yeah.
And they had a situation where one of the traveling nurses, who's a temp, right, or a contractor on site, went to a supervisor, the actual supervisor that she was reporting to on site, and said, hey, I need a flexible schedule. I've got these particular medical appointments. I kind of need an accommodation. And the supervisor said, well, I'm sorry, we're not going to do any of that because we're short-staffed, and the entire reason we hired this traveling nurse company was to fill these shifts. Well, she ended up bringing an EEOC charge against the company, not her traveling nurse company, but against our client, the healthcare institution. And the EEOC said, even under the ADA, these two entities, the healthcare institution and the traveling nurse company, could be deemed joint employers. And if the healthcare institution, if she's working on site and they're setting her schedule, they need to consider a reasonable accommodation. And so this led me to believe, do we need to have policies in place about how you request an accommodation?
Yeah, okay, so maybe what you should do is don't get out your employee handbook to like a temp worker or a contractor, but have a brief policy for them that outlines equal employment opportunity, that how to report discrimination and harassment and how your company doesn't tolerate it, how to request an accommodation if you need it. Like that's the type of thing that you would want to outline, and you probably want to specify even for an independent contractor or a temp worker that you don't engage in retaliation for any protected activity either.
Absolutely. And you can put on these types of forms or sort of have this be a policy or call it a reporting procedure, right? Or disclaimer for these temp workers or independent contractors, and have it even say on there that you're not their employer and that this doesn't establish a joint employer relationship. You can put it on there. You may not have a good argument. But you want to make sure that, for instance, as Emily mentioned, if that person is harassing your employees or they are being harassed by your employees, that they have an opportunity to bring that forward or they're at least on notice of what the policies are.
Yeah.
So take your company policies when it comes to EEO, harassment, accommodations, no retaliation, and make sure you put together some sort of a disclaimer for these workers.
Well, thanks for tuning in, and we'll see you next time on What's the Tea in L&E.